Hi, it's Katie Mackenzie, mortgage professional of Mackenzie Mortgage with TMG The Mortgage Group and your host of I Love Vancouver Real Estate. Thank you for taking the time to be with us today. We have the pleasure of having Len Atwood, Notary Public, Notary Matters with us today. Len was sworn in as a notary in 2012 and prior to this was an established business consultant and trainer who spent more than 20 years working with leading corporations, hospitals, and public agencies. Notary Matters provides a range of notary services related to real estate transfers, personal planning, and notarized documents. Today, we wanted to focus on the personal planning piece and as it relates to real estate, obviously, with a podcast with a mortgage broker. But Len, thank you for being with us today.
Thank you, Katie, for inviting me.
Welcome. So let me start by asking, is there anything that we should know about you and what you do in your practice?
Well, my practice is located on the outskirts of Yaletown, so it's there's plenty of parking. It's walking distance for many people, and it's close to SkyTrain. I've been in business, as you said, for just about 5 years, and so prior to that, I was a computer programmer, did a lot of programming, so I have attention to detail. I did a lot of software training, so I'm comfortable at helping people to simplify the complex and put them at ease.
Excellent. So how did you end up going from that into the notary side?
Well, I had often told people, it's great to learn new skills, and I thought I wasn't walking my own talk. So I had been on the lookout for Len 2.0 and how I would reinvent myself. And it was actually a friend who had just come from a notary, and she was telling me about her experience and ended with, Len, you'd make a great notary. And I looked into the profession and thought, yeah, that would be a great logical progression for me.
Fantastic.
Dealing with people, working in a knowledge-based industry and just helping them understand what's going on.
Yeah. Well, I asked you to come in today because I wanted to talk about, specifically that personal planning piece, wills, powers of attorney, representation agreements. I know that I touch on this topic with most of my clients, and it sort of grazes over because they want to get into the detail of what's their mortgage rate and how much is their payment. And the conversation gets lost. And I always try to ensure to bring it back and bring it forward as a key part of their financial planning strategy. So tell us then, what are the documents that you would recommend consider as a part of their personal planning piece?
Right. So you touched on three of them. There's actually four that are part of personal planning. So the will, which is for when you pass away, and then the other three are for while you're alive. There's a power of attorney, a representation agreement, and an advance directive.
So why would someone want to prepare a will?
Sure. So as a Canadian, one of the freedoms that we should be proud of that we have is testamentary freedom, or the ability to write a will, and you get to decide how you're going to gift out all your possessions, your investments, your cash. You get to decide who you're going to give it to and how much you want to give them. So that's a really neat freedom. And as part of that, you also get to appoint who your executor is. So the executor is the person who you give legal authority to act on your behalf to follow the wishes that you've documented in the will. They're kind of like a project manager. You also, in a will, get to appoint a guardian for looking after minor children. And it's also where you can state what your preferences are for funeral arrangements, burial, cremation, that type of thing.
Now, there are certain tax efficiencies that you can build into a will in terms of asset distribution.
Yeah, as part of the process of drafting the will, we have an interview where we go through what it is that people own, and we talk about what happens with the different assets at death so that they can plan for them. You can do a spousal contribution to an RSP through the will. So there's a few things we can look at.
Excellent. So what happens if someone dies and they don't have a will?
So a common misconception is that everything goes to the government. That's not true. We have, by law, the Wills, Estate Succession Act dictates what would happen in the case of somebody dying without a will, or intestate is the word for it. And that's not necessarily what you or I may want to have happen with our assets. So, for example, if you had a spouse, children together, and then you had children from another relationship, by law then, the Wills, Estate Succession Act says that $150,000 goes to the spouse, and then the remaining assets you have get liquidated and distributed equally between the spouse and all the children. So you don't have any control over how that's going to be given out.
Now, if you have an asset like a home and you want it to go to a certain individual within the family or to be donated to charity, you'd want to have a will in place,
So you've got
and
control.
an explanation of what you'd like to see done with that.
Absolutely.
Right? Okay.
Absolutely, as well as all your other investments. Plus, with the will, you're appointing who the executor is.
Mm-hmm.
Without a will, somebody steps forward to do that, and it may not be the person that you would want. And if nobody steps forward in your family, then the public guardian and trustee will do it, but they'll do it for quite a hefty fee.
Mm-hmm.
So dying without a will can be much more costly, and it takes a lot more time as well. So that means your loved ones aren't going to see anything from the estate for a longer period of time.
Yeah. Now, what specifically happens with real estate at death?
So it depends on how you hold it. So when you purchase a property, one of the questions you'll be asked is whether you want to hold it as joint tenants or tenants in common. So say it's a couple and they hold it jointly, then it passes outside of the will. It means it will automatically go to the survivor and not go through the will at all. That's typically how most couples, romantic couples, would want to hold the property.
Yes.
But if you're buying a property with, say, your siblings or with just a business partner, then you probably would hold it as tenants in common. And this means that if either person passes away, then their share passes through their will.
Mm-hmm.
So that asset may or may not be part of the will, depending on how it's held.
Mm-hmm.
But if, say, it's a couple and they both die together in a common accident, then the joint tenancy gets severed and each party would get 50% of the home, and it would pass according to their will wishes. So you can't just count on having joint tenancy to pass the property over to the spouse, because if you die together, you still want to have a will in place.
Mm-hmm. Now, so let me ask you, if you're buying real estate, do you recommend someone has a will?
Absolutely. That's
Yes.
part of it. Part of my conveyance process is to make sure that they've got all the documents in place.
So the next document then is power of attorney. So what is that and why would someone want one?
Right. So the term attorney is a little confusing. It doesn't mean a lawyer. The attorney is the person who you appoint to be your stand-in, who can look after anything financial or legal in your place if you're unable to.
Mm-hmm.
So it can be things like paying bills, dealing with your strata, managing your investments, or even selling a property. So there's two types of powers of attorneys. There's specific and enduring. A specific would be for a specific purpose and time period.
Mm-hmm.
So if I was going to move or be out of the country traveling and I'm selling a property, I might want to appoint someone to be my attorney so that they can deal with everything in the sale while I'm away. That would be specific, and I could even say that it's for a 2-month period. People will put together powers of attorneys for selling cars, other types of purposes like that.
Mm-hmm.
A more common power of attorney, though, is what's called an enduring power of attorney, which means it will endure if the person is ill, has dementia, doesn't have the mental capacity. And so this is the type of a power of attorney you want to have in place before it's needed, because if you have dementia, you're not going to be able to legally draft one.
Yes.
So you have this in place, and it's just there to appoint somebody who can help you if the need comes about. And I'll give you a couple examples where I've been called into the hospital often to draft these documents, and there's 2 cases where I wasn't able to help the people because they didn't have the mental capacity.
Mm-hmm.
In the one, the wife had called me in, her husband was sick, and he was on too many drugs at the time to be able to have the capacity to draft this.
Mm-hmm.
But the car insurance came due, and the car was in her husband's name, even though she drove it, and so she wasn't able to renew the insurance and wasn't able to come and visit him easily. The second case was a sister whose brother had lost his leg in an accident, and she knew he was never going to return to his 3-story walk-up and wanted to cancel the lease on his apartment and some of his other bills like cable and stuff to save him some money. And without the power of attorney, she couldn't help him out.
Mm-hmm. The same would be true then trying to effect a sale of a property to pay for the care of said individual. I've seen that occur.
Yes.
Where someone holds multiple properties and they're unable to sell a rental because they don't have that power of attorney in place.
Yes.
Yeah. So briefly touch then on the other 2 documents that you've mentioned in personal planning.
Yes, sure. The other 2 have to do with healthcare. So a mistake that some people have is they think that when they create a power of attorney, that person could make healthcare decisions for them, and that's not true. Power of attorney is only for financial and legal assistance. For healthcare, you need another document, which is called a representation agreement. And that allows you to appoint what's called a substitute decision maker, someone who can stand in your place. Of course, if you can speak for yourself, you'll make your own decisions around healthcare. But if you can't, then you can appoint a representative who can make these decisions for you. Without a representation agreement, it falls to your next of kin, and you may be happy with that. But sometimes people don't want their family to be making those decisions, and they would prefer to appoint the person outside of the regular pecking order to do that for them. If you don't have anyone who can be a representative, you can create what's called an advance directive, where you document in advance your thoughts about different types of healthcare. It's called a living will in other places. And so if you've got strong beliefs around end-of-life care, what you would or wouldn't want to have happen, then you can document that in place, and then the medical establishment will know what your wishes are.
Yes. And those are really important. I know I've gone through this a lot recently with family members, that those documents are key, and the healthcare system, the professionals that are within that system are very good at following up on what those wishes are and requesting copies of them so that they can ensure that those are met in that end of life period.
Yeah, and it also creates a little more family peace as well. So if there's arguments about, well, what would Katie or Len want to happen in such situations, you've already thought about it and documented it so people can follow your wishes.
Yeah, so that too, that family isn't having to make those difficult decisions on behalf of the individual. So when would people think about preparing any or all of these documents? Like, when is the right time to have these done?
So, of course, the answer is yesterday. We can't predict elections, the stock market, the weather, and you can't predict when a time of crisis is going to come. So you want to have these in place before you need them, and you want to prepare them while you have mental capacity so that there's no question about whether they're valid. But typically what I find is people will come to me when they have children. Often they want to draft a will to make sure there's a guardian appointed in case something were to happen to the parents. When they start accumulating assets, they want to be able to protect them with the power of attorney so that somebody can be appointed to manage those things if anything happened to them. Or as you get a little older and someone close to you has health issues or dies, you start realizing that we all are going to face this at some point, and you want to have them in place beforehand.
So I always touch on this when clients are applying, because generally, they're buying a large asset. So do you have one in place, or have you revisited it? Or in a life event, so new children, a new marriage, although marriage, as you said, does not null and void any existing will. The existing will continues forward, so that should be revisited in marriage.
Yes.
Should you wish to change it.
Before the Wills, Estate Succession Act, we had different legislation. So pre-2014, if you were wrote a will and then later married, it annulled the original will. That doesn't happen anymore, but probably the original will isn't going to be what you would want now that you're married. So it's a good time to revisit.
Now, for these documents, I haven't asked you this before, registering them so that people can search for them.
Yeah, there is a couple of registries where you can place these. So Vital Statistics, BC Vital Statistics has a registry. It's not as good as you would think. They don't keep a copy of the will. They just keep a record of the fact that you wrote a will on a particular day where you're storing it. So it can help people later find the will and also verify whether it's the last and most recent will.
Okay.
But it's not an actual copy of the will. You want to store that in a safe place.
So what's your process? Someone comes in to meet with you and says, I've listened to your podcast and I have not done these documents. I'd like to do them. What does that process look like?
Yeah, so the process is really simple. It's first I send out a questionnaire so you can think about things like what are your assets? Who are your dependents? Who do you want to gift to? Who would be an appropriate person to be your executor? So you think about those things in advance. Then we meet, we review through the questionnaire. It's usually about a 45-minute, hour-long meeting. Then I'll draft the document. We go back and forth, usually through email. And when you're happy with it, then you'll come back in and we just do a quick signing, make sure it's all official, and then it's done. So they're really easy to draft and they're easy to revise later. Often I find some people will delay putting these documents in place because they think, oh, my life's going to change. I know one day I'm going to get married. I'll wait and do it then. Or I'll wait till I have kids and then I'll put it in place. But the reality is you can draft these and change them very easily, and they're not expensive to draft or to change.
I think maybe some of the hardest pieces are deciding who you're authorizing to have power over. That to me would be the longer decision-making process and time. Who do I authorize?
And it's going to change with time too. Appropriate person right now might not be an appropriate person in 20 years.
Absolutely.
You know, you might put your parents on when you're 30, but they might not be the right people to be your executor when you're 60.
Yes, yes. Another piece too, I think, once they have been drafted and prepared by you, is presenting those documents to the financial institutions that you may have to work with. Because I know I've seen this from my experience when I was with Scotia. Clients would have the documents prepared, they think everything is great and in order, and then there'd be another step to have the verification done with each and individual financial institution. So presenting those documents to, say, your bank that you deal with and say, you know, what would I have to do, or what further verifications do I have to provide to you should I need to act on these?
Great suggestion. Yeah. Sometimes people are preparing these a week before they go traveling for 6 months, and they know that power of attorney is going to be used.
Yeah.
Their friend or a sibling is going to be using it to keep their bills maintained, and so it's better to present that, make sure it's all vetted, and the branch knows that it's going to be used, and then there's no issues.
And I never recommend buying real estate and leaving the country, because some lenders will not actually authorize the use of a power of attorney. So just make it
especially on the purchase side. Yes, on the sale side's easier, but purchase for sure.
So is there any difference in using a lawyer or a notary to prepare the personal planning documents?
Yeah, so either could prepare these documents. The one place where I would recommend a lawyer, though, is if there's any trusts involved. Notaries don't do trusts, so our wills are what they call simple wills. Everything is given out at the time of death. Of course, if there's minor children, they don't get their gift until they're of age 19. But if you have disabled beneficiaries or any other situations where you want to delay the gift giving or spread it out over time, then you should speak with a lawyer.
Okay. So now, why would clients want to work with you above and beyond for the preparation of these documents? What makes Len Atwood at Notary Matters better than any other notary that we know?
Well, I think you really want to choose someone who you're comfortable working with, especially when you're preparing personal planning documents. You want somebody who's knowledgeable, but you also want somebody who you feel comfortable discussing your family and your finances with. You don't want to hide things from your notary, otherwise you're not going to be putting together the best plan. And with real estate conveyancing as well, that's another area that I focus on. You want somebody who's convenient, who's going to explain the process to you, and who you're comfortable with.
Absolutely. I always say that. I say if you're uncomfortable with who you're working with, stop working with them. Let them know why so that they can understand. But yeah, it's paramount too, because it takes quite a bit for people to feel comfortable, as you mentioned, discussing personal information, but what happens at death or just prior to death. Those are difficult conversations for some people to come forward with.
Absolutely. Because I was a trainer in a past life, I really want to make sure people understand what they're doing and they're comfortable with what they're doing, as opposed to just pushing papers and saying sign here, rushing through the process.
Absolutely. So then let me ask you, do you have your personal planning documents in place?
I do, and I revise them regularly because I can.
Yeah, I just did mine. Because, of course, we had a family member pass away, so I needed to update that. But highly recommend that people do reach out to Len, have the discussion with regards to these documents at any stage. If you have one written, have you reviewed it? Is it up to date? Does it need to be changed? If you don't have one, you should have one, regardless of assets or dependent children or a partner. Highly recommend it. So Len, how can people get a hold of you to do that?
Sure. My website's notarymatters.ca, or if you wish to call me, my phone number is 604-569-2779.
Excellent. Well, thank you for taking the time to be with us today, and thank you to our listeners. We know there's valuable information that we've provided today, and again, that you probably have other questions or unique situations specific to your personal financial plan. Please do reach out to Len or myself. Also, make sure to share the podcast for anyone that you think could value this information, and subscribe to the podcast on iTunes for future episodes. Leave us a review, and until next time, I'm Katie Mackenzie, mortgage professional with Mackenzie Mortgage at TMG the Mortgage Group, and your host of I Love Vancouver Real Estate.